Welcome to LexTalks Legal Topics Simplified, where we like to break down complex legal concepts, especially for all you law students out there.
Mm,
In India,
exactly.
today we are diving deep into
Legal.
the Indian Forest Act of 1927.
Okay.
Specifically, we're going to be focusing on protected forests, reserve forests, and village forests.
Sounds good.
You might be thinking, forests? What's so complicated about that?
Right.
Buckle up.
Yeah.
This act has a rich history, and its impact on communities and conservation is huge.
Absolutely. It's a cornerstone of environmental law in India.
Yeah,
And understanding it is crucial for any aspiring lawyer here.
for sure.
We'll unpack how these classifications determine how forests are managed and who gets to use them,
Right.
and the fascinating legal battles that have sprung up around them.
It's amazing how a law from 1927 is still so relevant today, right?
Oh, absolutely.
It's like looking through a window into India's evolving relationship with its forests.
What's fascinating is how this act has been amended and reinterpreted over the decades, reflecting the shifts in thinking about forest management,
Right.
conservation, and community rights.
Yeah.
It really is a living document.
Okay, so let's get started. First things first, India clearly takes its forests seriously.
Yeah.
Nearly a third of the country is forested. And that's not just about pretty trees.
No.
It has huge implications for the environment and the economy.
Exactly. Managing these vast resources involves a complex balancing act. You need to juggle conservation goals with the needs of communities who depend on forests for their livelihoods.
Right.
And of course, economic interests that see forests as a source of revenue.
So how does this 1927 Act, drafted during the British Raj, even begin to address these modern challenges?
Well, it's been through a lot of changes. Think major updates in 1988, 1992, and a particularly significant one in 2002.
Okay.
But before we get into the amendments,
Yeah.
let's break down those three key forest classifications you mentioned: reserve forests, protected forests, and village forests. Each has its own set of rules and implications for people on the ground.
Sounds good.
Yeah.
Let's start with reserve forests. I imagine these are the most heavily protected.
You're right. Think of them as the fortresses of the forest system. The government holds the ultimate authority over their management,
Okay.
and the rules governing activities within them are very strict.
So are people completely excluded from reserve forests?
Not necessarily.
Yeah.
Here's where it gets interesting. Originally, the act did allow for something called settlement of rights.
Hmm.
Individuals or communities could claim rights to resources within these forests. Imagine generations of families relying on a specific area for medicinal plants or firewood.
Right.
The act had a process for assessing and recording these claims.
There was a legal way for people to have access to resources within these protected areas.
Yes, and there were even provisions for appeals if a claim was rejected, and in some cases, compensation was offered.
Wow.
However, over time, the focus has shifted more towards stricter control, and recognizing those traditional rights within reserve forests has become less common.
That creates a lot of tension, right?
Yeah, it does.
On one hand, you want to protect these crucial forests, but on the other hand, you have communities who've depended on them for generations.
Yeah.
How do you reconcile those competing interests?
It's a difficult question with no easy answers.
Right.
The Act has grappled with this tension throughout its history, and it's something you as future lawyers might have to consider: how to advocate for both conservation and the rights of those whose lives are intertwined with these forests.
Okay, so we've got these fortress-like reserve forests.
Right.
What are protected forests? Are they a bit more relaxed?
You could say that protected forests offer a middle ground.
Okay.
The government still regulates activities like clearing land, but there's often more recognition of traditional rights, making it a more nuanced category. This is where the balancing act gets even trickier.
I can see that. It's about trying to find ways for people and forests to coexist sustainably without one completely overriding the other.
Precisely. It's a challenge that India continues to navigate.
Which brings us to the third category, village forests. These sound very different.
Village forests are specifically assigned to local communities for sustainable use.
Okay, interesting.
It's an acknowledgement that communities often have deep traditional knowledge about their local ecosystems
Okay.
and a vested interest in managing them responsibly.
So this is where the power shifts to the people, right?
Exact.
They get to decide how these forests are used and protected.
It's an approach that recognizes that sometimes local communities are best equipped to manage their own resources. It's about empowerment and recognizing the value of traditional ecological knowledge. It's fascinating how the concept of village forests challenges the traditional top-down approach to forest management. It really is a recognition of the deep connection between communities and their surrounding environments.
It's like the act is saying, Hey, you've been living in harmony with these forests for generations. You know what works best. But let's be real, the Indian Forest Act wasn't always this community-focused.
You're absolutely right. Historically, it was all about control and enforcement by forest officers.
So how did this shift towards community involvement happen? Were there specific changes to the act that made this possible?
Yes, definitely. Remember those amendments we talked about earlier?
Yeah.
Well, they played a key role in shaping the act into what it is today.
Let's talk about those amendments in detail. What kind of impact did they have?
Well, take the 1988 amendment, for example. This one was all about bringing local communities and even NGOs into the picture.
That's a big departure from the British Raj era approach.
It was. The amendment actually allowed the government to assign forest land to village communities for afforestation.
So instead of just protecting existing forests, they were actively encouraging communities to plant more trees.
Exactly. And it went beyond just planting trees. This amendment acknowledged that local communities have a vital role to play in protecting and restoring forests.
I can see how that would make a huge difference. If people feel a sense of ownership and responsibility, they're more likely to protect the forests.
Precisely. And this amendment also opened the door for NGOs to assist in forest development programs.
Bringing in expertise and resources from outside the government.
It was a step towards a more collaborative and participatory approach to forest governance. And then in 1992, the act was amended again, this time focusing on the issue of encroachments.
Encroachments. You mean people illegally occupying or using forest land?
That's right. This amendment gave the government more legal muscle to protect forests from these unauthorized activities.
What kind of tools did it provide?
Well, for starters, it laid out penalties for offenses like unauthorized felling of trees, quarrying, and even pollution that could harm the forests.
So they were getting serious about protecting these resources.
Absolutely. And it also empowered forest officers to prevent and detect forest offenses more effectively.
I imagine that also led to some friction with communities who had been using those lands for generations.
It definitely highlighted the ongoing challenge of balancing forest protection with the needs of local communities.
It's that constant tug-of-war we talked about earlier.
Right. But then perhaps the most game-changing amendment arrived in 2002.
This is the one that recognized the rights of forest-dwelling communities, isn't it?
It is. This amendment was monumental because for years these communities had been marginalized, their traditional rights ignored.
Their way of life was intrinsically connected to the forest, but the law didn't recognize that.
Exactly. But the 2002 amendment aimed to rectify that. It provided for the settlement of rights for people who had been living in the forests before December 2005.
So finally, their historical connection to the land was being acknowledged.
It was a huge step towards empowering forest-dwelling communities and giving them a voice in how forests were managed.
And this amendment also brought Gram Sabhas into the picture, right?
Yes, it did. The 2002 amendment recognized the role of Gram Sabhas, which are essentially village councils, in determining the nature and extent of individual or community forest rights.
So decisions about forest management were no longer just being made by officials in far-off offices.
Exactly. It brought decision-making power down to the community level. But here's the thing about the Indian Forest Act. It's not a static document.
It's constantly evolving, just like the relationship between people and forests.
Right. These amendments highlight the constant back and forth, the ongoing debate about how to balance competing interests in India's forests.
It's like a living organism, adapting to changing social, economic, and ecological realities.
And that's what makes it so fascinating from a legal perspective.
Hmm.
Now, shifting gears a bit, let's talk about how courts have interpreted the act.
How have judges grappled with this complex piece of legislation?
Well, remember, the Indian Forest Act isn't just a set of rules on a piece of paper. It's a framework that needs to be applied in real-world situations.
And those situations can be messy and complicated.
They can. Over the years, courts have had to wrestle with some really tough questions related to the act.
Questions that go to the heart of how we define forests, how we balance competing rights, and what the limits of government power are.
Exactly. And through their rulings, judges have helped clarify some of the ambiguities in the act and offered guidance on how to apply it fairly and justly.
Do you have any examples of cases where the courts had to make tough calls?
Absolutely. One fascinating case involved the question of what constitutes forest produce. Sounds simple, right?
Well, I'm guessing it's not as straightforward as it sounds.
You're right. This seemingly basic question had huge implications for communities who depended on forests for their livelihoods.
Because if something is classified as forest produce, It falls under the jurisdiction of the Indian Forest Act, right?
Exactly. In this particular case, the court had to decide whether tendu leaves, which are used to make traditional beaties, could be considered forest produce,
And if they were, that would mean their collection and sale would be subject to the Act's regulations.
which could potentially impact the livelihoods of millions of people.
Wow, so the stakes were really high.
They were. Ultimately, the court ruled that tendu leaves were indeed forest produce. But here's where it gets interesting.
They didn't just stop there, did they?
No, they didn't. The court also recognized the vital role these leaves played in the economic well-being of tribal communities.
So they tried to strike a balance.
They did. They emphasized the need for considering both conservation and livelihood concerns when applying the act.
That's a great example of how judicial interpretations can shape the real-world impact of the Indian Forest Act.
It shows how the act is not just some abstract legal text. It's a dynamic force that interacts with the lives of real people.
And that's why understanding this act is so crucial for aspiring lawyers like our listeners.
Hmm.
It's not just about memorizing provisions, it's about understanding the human stories behind them.
Exactly. You need to grasp the historical context, the competing interests, and the real-world consequences of legal decisions.
It's about seeing the big picture and understanding the impact these laws have on people's lives and the environment.
Absolutely. And speaking of the big picture, there's one more crucial aspect of the Indian Forest Act we need to discuss: village forests.
These forests represent a unique approach to forest governance, one that puts communities at the center. So we've talked about reserve forests and protected forests where the government has a significant role. But village forests are a whole different story. It seems like the Act acknowledges that communities can be the best stewards of their own resources.
That's right. These forests are a testament to the idea that sustainable forest management often works best when you empower those who live closest to the land. Instead of imposing rules from above, village forests flip the script and give communities the authority to manage and protect their own forests.
It's a fascinating concept. But how exactly does it work? Does the government just hand over control of the forest and step back completely?
Not quite. It's more nuanced than that. The Indian Forest Act empowers the government to create village forests through a process of assigning specific forest land to local communities. This formalizes the community's right to use and manage the forest's resources.
So it's like a legal recognition of their traditional relationship with the forest.
Precisely. But with that recognition comes responsibility. The idea isn't to give communities free rein to exploit the forest. It's about sustainable use, ensuring the forest's health and productivity for generations to come. And that's where the government still plays a role.
So there's still oversight and guidance from the government.
Yes, definitely. The government can set rules for how village forests are managed, such as what can be harvested when and in what quantities. They can also work with communities to develop management plans that prioritize the long-term health and sustainability of the forest.
It sounds like a collaborative approach.
Mm-hmm.
What are some of the key benefits of this model?
Well, one of the biggest benefits is that it taps into the wealth of traditional knowledge that communities have about their local ecosystems. They often have a deep understanding of the delicate balance that exists within the forest and what's needed to maintain it.
It's like generations of accumulated wisdom about how to live in harmony with nature.
Exactly. And by empowering communities to manage their own forests, it creates a sense of ownership and responsibility, which is essential for long-term conservation efforts.
But as with any system, I imagine there are challenges associated with managing village forests.
You're right, there can be challenges. For instance, sometimes the government's vision for how a village forest should be managed might clash with the community's traditional practices, or there might be internal conflicts within the community over how the forest should be used and who benefits from its resources.
It's a reminder that even with the best intentions, managing shared resources can be complex and messy.
It definitely is. And let's not forget the external pressures that communities often face from industries that might seek to exploit forest resources for their own gain. These challenges highlight the importance of ongoing dialogue and negotiation between the government communities and other stakeholders.
So effective communication and finding common ground are crucial for the success of village forests.
Absolutely. It's about finding solutions that are equitable and sustainable, respecting both the needs of the community and the ecological integrity of the forest.
We've covered a lot of ground in this deep dive into the Indian Forest Act of 1927. We've explored its historical evolution from its colonial roots to the significant amendments that have shaped it into what it is today. We've looked at the different categories of forests: reserve forests, protected forests, and village forests, and the complexities of balancing conservation goals with the rights and livelihoods of communities.
And we've seen how judicial interpretations have played a crucial role in clarifying ambiguities and ensuring the act is applied justly in real-world situations. It's a fascinating journey through the intersection of law, ecology, and human society.
For all you future lawyers out there, remember that the Indian Forest Act isn't just a theoretical construct. It's a living, breathing framework that has a profound impact on the lives of millions of people and the fate of India's forests.
As you delve deeper into the world of environmental law, keep in mind the principles we've discussed today, the importance of community participation, the challenge of balancing competing interests, and the constant need to adapt and evolve in response to changing circumstances.
Thanks for being part of LexTalks. We hope you found this deep dive insightful, and we encourage you to continue exploring the fascinating world of environmental law.
Subscribe and keep learning.